Good afternoon, Excellencies, colleagues, dear friends. I'm very pleased to welcome you to the side event on the margins of International Legal Week, organized by the Permanent Mission of Armenia to the United Nations in partnership with the International Law Association American Branch and the Armenian Bar Association. Today's roundtable discussion will seek to address one aspect of international legal practice, which plays a critical role in defining the conduct of legal practitioners in administration of justice, in particular, one that involves ethical considerations for advocates representing state clients. Discussions will also look into the role played by practitioners themselves in developing, implementing, and enforcing ethical standards, as well as the role of international community in this regard. It should be noted, perhaps by way of brief introduction, that historically, international efforts seem to have been focused primarily on setting ethical standards for the conduct of judges. These are most prominently grounded in the landmark basic principles on the independence of the judiciary, adopted in 1985, as well as the principles of judicial conduct in 2003, which outlined the values of independence, impartiality, integrity, propriety, equality, competence, and diligence as necessary to ethical conduct of judges, and which at the time of their adoption represented a major step towards filling the gap in the international legal framework regarding judicial ethics. Colleagues, today's event is an important opportunity to not only take a closer look into the question of ethics as it relates to the work of lawyers and advocates, but also to initiate a conversation which could lead to further efforts on national, regional, and international levels to address this particular aspect of legal practice. For Armenia's part, domestically, we have been consistently working to codify progressive ethical norms and standards governing the conduct of lawyers as manifested through relevant legislative framework, notably the law on advocacy. The Code of Conduct adopted by Armenia's Chamber of Advocates has been essential in prescribing ethical standards grounded in the norms and principles of the Code of Conduct for European lawyers. In close collaboration with the Council of Europe, legal professionals in Armenia are offered comprehensive training courses on ethics and integrity, which are conducted for judges, prosecutors, and lawyers. And we are keen to continue to exchange views and experiences and to foster further cooperation. In debating the questions of ethics and integrity, especially as they apply to administration of justice at the international level, one cannot disregard the role of the context in which practitioners operate and continue to shape evolving ethical standards. Often, these are extensively influenced by choices and decisions about clients and cases that lawyers can select in representing states before international courts and tribunals, whereby the nature of the client government itself could well define the advocate's ethical record. This can be particularly true for lawyers representing states with flawed record in human rights, corruption, and the lack of rule of law domestically. More often than not, such governments turn to international institutions to repurpose and reshape international norms and standards, and use tools of international litigation to preserve the ability to repress. Our very own national experience involving a case against the state with the worst human rights and corruption record in Europe, and indeed in the world, is a case in point which has already demonstrated particular advocates' ethical volatility. Colleagues, in the absence of effective protection mechanisms against state interference, exacerbated by the rise in hate speech, misinformation, and disinformation, it is important to examine more closely the ways in which voluntary and binding ethical standards can impact the conduct of advocates before international courts and tribunals. It has been suggested that it is indeed possible to achieve the creation of an international judicial culture grounded in common values, of ethics, responsibility, and solidarity, and that one way to realizing this long-term objective would be by means of creating a regulatory authority to ensure some form of internationally verified oversight. I'm sure our distinguished panelists will have a chance to elaborate on this in more detail in course of today's conversation. This brings me to an end of my welcoming remarks, and I now have the distinct pleasure to introduce today's panel. I was informed that unfortunately Ms. Miriam Al-Rashid, partner from Evershed Sutherland, a law firm, could not join us at this time, and we wish her good health. We are very lucky to be joined with Professor Chiara Giorgetti from the University of Richmond School of Law, Mr. Alex Petrosian, Associate from Hughes Hubbard, a law firm, Washington, Dr. Arma Sarvarian, University of Surrey, United Kingdom, and I am very grateful to Mr. Grant Hanessian, independent arbitrator and neutral in New York, who will moderate today's session. Our session will be webcasted online on UN Web TV, and I also want to take this opportunity to thank all the attendants of today's roundtable discussion. I know there are several parallel events going on in the framework of International Legal Week, and I want also to particularly thank the staff of the Permanent Mission of Armenia to UN for putting together this event. I thank you all, and I wish you as fruitful deliberations. Grant, please take the central seat.
Thank you, Mr. Ambassador. Thank you all for coming. It's a great privilege for us to be here. Let me just give you a few more words about our panelists here. I was a lawyer with Baker McKenzie for 33 years until, excuse me, 2 years ago, when I established a practice as an independent arbitrator. I was the head of the International Arbitration Practice Group at Baker McKenzie for a time. I've represented states and state entities for many years in many sorts of disputes, and now I'm acting as arbitrator in these disputes. Miriam Al-Rashid, as was said, was unable to be with us today, but we're grateful for our panelists that we do have. Dr. Arman Savarian, as you've heard, is with the University of Surrey in the UK. Many of you will know him from his work in this building, including this week, on various UN projects. He is the author of one of the first monographs in this on this subject called Professional Ethics at the International Bar, which was published by Oxford University Press in 2013. Very widely cited work in this area. As I've said, he continues to work on the Sixth Committee here and is very active in publishing and speaking on the topics that we'll be talking about today. Professor Chiara Giorgetti of the University of Richmond is also a specialist in this area, having written extensively on it. She's extremely active in public international law organizations, including the American Society of International Law. She sits on the executive committee and is vice president of the American branch of the International Law Association. And to my right, Alex Bedrosian, who is a lawyer in Washington with the Hughes Hubbard firm. Notwithstanding his relative youth, Alex has represented states and acted adverse to states on every continent in the world. So he's been very active in his practice in both public international law and international commercial arbitration. So if we could go to the first slide, please. Our plan here is to just very briefly set out the ethical standards that apply in these cases to counsel in international cases. Then we have a series of problems that our panelists will discuss. This will be an interactive discussion among the panel, and we'll have time for questions and observations from all of you. So at a high level, one can say that there are two sources of standards that guide ethics of lawyers in international cases. What we call a home standard and what we can call an international standard. So the home standard would be the ethical obligations in the jurisdiction in which the counsel is qualified. All right, lawyers, of course, are admitted to practice in their home jurisdiction, the state in which they work. And we've characterized this as a default approach. The advantage of this, of course, is the counsel is aware of these rules. They're admitted to practice under these rules. And depending on the jurisdiction, the rules are predictable and transparent and are enforced as such. Excuse me. Disadvantage, of course, is that people are admitted in different states with different rules. So you have a potential inconsistency and asynchronicity between the counsel in a given case, and this potentially could lead to certain unfairness. Okay, then we speak of the international standards. So these would be ethical obligations that would be applicable to all counsel appearing before a particular tribunal or in the seat or the place that the tribunal is sitting in. The advantage there is that there's a consistency and a fairness. The same rules apply to everyone. The disadvantage is that these rules are not well formed or applied, and the arbitration institutions, tribunals, and international courts are reluctant to function as regulators. Next slide, please. So the home standards, of course, depends very much on the jurisdiction. In the United States, we have the American Bar Association model rules of professional conduct, but every jurisdiction, of course, has its own standards of professional conduct for attorneys. The international standards, here you see a list. This is not a comprehensive list, but these are the major sources of an international standard. The first is 2005, International Criminal Court Code of Professional Conduct. 2010, International Law Association Hague Principles on Ethical Standards for Counsel appearing before international courts and tribunals. 2013, the International Bar Association Guidelines on Party Representation in International Arbitration. Dr. Savarian worked on that. In 2020, the London Court of International Arbitration issued the first professional conduct guidelines of any of the commercial international arbitration institutions. And then just last year, 2021, ICA, which is a International Commercial Arbitration Organization, issued guidelines on standards of practice in international arbitration. So again, these guide counsel. There are other sources that we could refer to with respect to arbitrators, but these guide counsel. Next slide, please. So there is some jurisprudence on this in the Fraport against Philippines case from ICSID case, investment treaty case from 2008. The annulment proceeding is very frequently cited in this area. And the tribunal there said that the home jurisdiction standard is valuable to the extent that it reveals common general principles which may guide the committee, the annulment committee, but none of it directly binds the committee as an international tribunal. Accordingly, the committee's consideration of the matter is not and should not be based upon a reading of any particular code of professional ethics applicable in any particular national jurisdiction. Rather, the committee must consider what general principles are plainly indispensable for the fair conduct of the proceedings. So you can see that's a fairly high-level statement there, and we'll talk about some of the applications of that in the problems that we'll talk about today. So particularly with representation of states, for lawyers representing states, and particularly for lawyers employed by states, working for the states within the government, there's a question, and we'll consider this from various perspectives. is the duty of fairness, candor, and honesty for state lawyers inconsistent with or subsidiary to a duty of loyalty to the sovereign, to the state? So with that general background now, we'll turn to our problems, and I'll ask Armand to continue with the first of these. If we could go to the next slide, please.
Thank you very much. As our chairman mentioned, I'm involved in the work of the Republic of Armenia before the Sixth Committee and Ancestral Working Group 3 on investor-state dispute settlement reform. And so I make the necessary disclaimer that everything I say in my personal capacity. What is Council's obligation where there is procedural misconduct by a state party? Two initial points. One is define procedural misconduct. As we'll see, that's quite important. And the other, that this is not restricted to state parties. It could apply to any disputing party, but we're focusing on state parties. The first example, ex parte communications between Council and a party-appointed arbitrator. Now in Ancestral Working Group 3, we are developing a draft code of conduct for arbitrators in which this problem arises, and we found it to be rather more difficult than we'd initially assumed to define ex parte communication. I think we have reached a satisfactory definition, but it did require more time and discussion than we'd initially anticipated. Examples of this in practice, the rather dated arbitration, but the Burami Oasis arbitration, which involved close contacts between an arbitrator and the agent of the state concerned, concerning the draft award and the outcome of the arbitration. The arbitration was ultimately abandoned because it was considered to be fruitless to continue in light of that, and so that resulted clearly in a waste of resources. Another example, much more modern one, the Gulf of Piran arbitration, in which similar sort of facts, the party-appointed arbitrator was caught in discussion with the agent of the state concerned with respect to the draft award and the specifics of the draft award, in particular how it might be amended to arrive at an outcome more favorable to the state in question. Now, the arbitral tribunal in that case reached a conclusion, issued an award. The arbitral tribunal, I should say, as reconstituted, and that's a longer story than I'll trouble you with. But there are real questions as to the enforceability of that award. The second example, a failure to respect time limits and the use of so-called delaying tactics. I think this would be familiar to most lawyers in one form or another, but it's one of those questions where how long is a piece of string? Define it. It's quite subjective in a particular case as to whether delaying tactics have been used or not. Here we can speak of the duty of diligence with respect to counsel, with respect to, for example, respecting time limits, but one point that might be drawn out is that it rather depends on the procedural rules and the context in which counsel are operating. So, for example, the International Court of Justice amended Practice Direction 3 in 2021 to, for the first time, impose a page limit to the annexes to written proceedings of 750 pages. That was, I might add, that was a long time coming. There's a lot of discussion and context to that one, and it's not quite so radical as it might appear at first sight. But for the court, that was a step. So I'd refer in this respect to work in which I was involved of the International Law Association Committee on the Procedure of International Courts and Tribunals, which in 2020 issued a report with proposals for procedural reform to various interstate courts and tribunals. The point being that if we're talking about ethics on the one hand, we ought also to be talking about what the procedural rules actually provide, and so how counsel are expected to operate within them. It's quite vague to simply talk about diligence. The third example, the use of evidence obtained in alleged violation of national law. A similar point arises here. We've seen in various arbitrations, in particular investor-state arbitration, not only, also in interstate arbitration. We've seen examples such as WikiLeaks came up in the Chagos Islands arbitration. How was that to be handled? We've seen examples of documentary evidence in particular obtained by alleged leaks, breaches of confidentiality. How should that be handled? We've also seen a couple of dated examples, but nonetheless pertinent. Libananco versus Turkey and Metalcloud versus Mexico with respect to, for example, documentary evidence obtained by means of alleged trespass. So here, again, we don't have much in terms of the procedural rules of the respective international courts and tribunals as to how they are to handle such evidence. And so the question arises, if we're talking about ethics of counsel, they are operating within, there's lack of rules, really, as to whether the material is admissible or not. And so what ethical rule are they to fall back upon, whether they're home bar or any international standard that might be imposed? It's rather more complex than simply talking about the code of conduct. And finally, a rather extreme example, but nonetheless an interesting one, an abduction of a party-appointed arbitrator by agents of the state that had appointed him. This was not so long ago, 1999, Himpunan versus Indonesia, an investor-state arbitration. Now that, as I mentioned, is rather extreme, but there is a question as to what extent counsel were A, knowledgeable about the intentions, and B, then how were they to handle it? For example, do they continue to represent the party or not? And so that does raise pertinent questions with respect to ethics. And finally, I'd mention with respect again to evidence to investor-state arbitrations, Generation Ukraine and CDL Group, both of which gave rise to questions concerning the continued participation of counsel. And so in this respect, within Antitrust Working Group 3, an ongoing project with respect to investor-state arbitration is a proposed advisory center for investor-state arbitration. One of the questions there will be, or is, whether such an advisory center should provide pro bono legal services. And that's something that might apply to states on the one hand, and to small and medium enterprises on the other. Thank you.
Maybe go to the next slide, please. Yes. Do you want to tee these up for us?
So questions for discussion. First, what are counsel's obligations to a client when faced with allegations of client misconduct? Do they continue to represent or not, for example? Second question, what are counsel's obligations to a tribunal, as well as to the adverse party? And the third question, what are counsel's obligations if client misconduct reveals misconduct by the adverse party? And so if we're talking about wiretapping, for example, and that becomes known to the other side, this did happen, an arbitration not so long ago, how are counsel to handle that? Well, the obvious observation, first of all, is we lack international ethical standards applicable in these proceedings. There's no common ground, essentially. And if you look at the home bar rules, as our chairman mentioned, they are rather diverse. So take the example of evidence, how to handle documentary evidence obtained, or other forms of evidence for that matter, obtained in alleged violation of national law. There's no real agreement on this question amongst national legal systems. So falling back upon home bar rules, let alone other problems, which I won't go into, I would suggest be rather fruitless. But on the other hand, even if we could develop a code of conduct that would be applicable in the respective international courts and tribunals, and our chairman rightly pointed to the problem of their willingness to take on the task, which is the real question I would suggest on that. Even if we could achieve that, would such a code of conduct be sufficiently specific as to address these kinds of problems? My instinct, based on experience of crafting such guidelines within the International Bar Association and the International Law Association, is in the negative. I think when we speak about broad general principles, one has a duty of loyalty to the client. One ought not to mislead the court, something we'll come on to later. Fine, everyone can nod and go along with that. It's when one applies it to a specific situation that it gets quite tricky. And so the real source of inspiration, I would suggest, for that would not be the text per se, but rather the case law, the precedents. And we have some of that, but thus far largely avoiding the issue.
Kira, any comments?
Yes, thank you very much. I think Arman explained the problem very, very well. Thank you. But I'd like to also add two issues that I think can also help us kind of work through this example. And one is the issue of timing. So when does the council become aware of a misconduct by the state party, and does that matter in terms of how does the council behave? So for example, if like in your case, in your example 3, the state party eavesdropped on a conversation between adversary state agent and the state appointed arbitrator, or in case 2, the state party eavesdropped on conversation between adversary party and council. But mostly in case 1, what happens? When does the council know? Of course, in case 2, the council maybe was aware. But when does the council become aware, and how does that inform the consequences of that? And the second issue is, what are the remedies that are available? All right, because we are not in a domestic system, we don't have a bar association that can issue a remedy that can bar the representation or can fine or do whatever it's needed to be done. What might be the consequences of a misbehavior, and what are the consequences on the council itself? And I think we have to think about that also, because when we're thinking about creating an international code, and I think what we've seen also in Working Group 3 in relation to arbitrators, we would have the same issue in terms of council. Who has jurisdiction to decide on council, and how would that decision be enforced? Who would enforce it? Would we have maybe an ombudsman or an international bar association with specific powers? And how do we do it? And then also in international law, and I think is another issue to consider, there's no need to be admitted to a specific bar. So how does that also inform and influence what can be done in terms of procedural misconduct by a state party? Sorry, a little more kind of food for thought and to think about the situation.
Investment treaty tribunals do have the power under the ICSID system to exclude counsel, and there have been instances where that's been requested, and the tribunal's taken jurisdiction over the request and made determinations about it. Okay, you worked on such a case. In other fora, it's the law is still developing, but the standards that I mentioned earlier at the outset, these are fairly uniform in requiring that counsel be independent and exercise integrity and freedom from undue pressure by the client. And I do think the tribunals generally anticipate that attorneys will act in that way. And the misconduct that was described has occurred. Typically, the misconduct is admitted by the counsel, by the outside counsel. And the argument is not whether the misconduct occurred. The argument is about the remedy. What's the appropriate remedy in these cases? But it would be unusual and would not be effective counsel work if a counsel were to be perceived as implicated in the misconduct. I'll put it that way. It's typically, particularly the cases such as eavesdropping and such, that the counsel is able to tell the tribunal honestly that they had no knowledge of the conduct. So, all right, let us go to the next problem then.
I'll just say hallelujah to the page limits on this topic.
Yeah, 750. That really limits one's ability to argue, I would say. Legal services boycott, and we'll ask Chiara to introduce this, please.
Thank you very much. So here the question is a little different. And the question is, what are ethical obligations to start or continue representing a state in cases where a council considers the conduct of the state itself to be unethical. And so is there an obligation not to represent the state, or conversely, is there an obligation to continue to represent the state, for example, and taking there from a maybe the example of domestic criminal procedures, right? You have a right to be represented. So what are the tensions there? Is the decision to withdraw or engage in a representation is it governed or informed by any rules of professional responsibility, which are domestic or international? In terms of international rules, as we know, and as both Grant and Armand have already mentioned, there are no international rules that are mandatory. So here we really are looking at what the domestic rules and ethical standards and the rules of professional responsibility say. And here there are quite interesting examples. So really we want to go to the domestic standard here. And since February 2020, many important firms have, for example, sought to cease representation. The news just yesterday that's published on global arbitration, GAR, Global Arbitration Review, that White & Case announced that it would cease acting for Russian and Belarusian state clients and so cease to represent in investment state arbitration. So what are the consequences, and what are the responsibility and ethical responsibilities of counsel? And here it's quite interesting because we have some interesting cases that are recent cases that already look at this issue. And so, as I mentioned, several firms have asked to withdraw, and who do they ask? They ask, so there has to be a request to withdraw from case representation, and here we have several firms that have asked to withdraw to U.S. district courts in the District of Columbia in D.C., and to do that, counsel and firms have to provide a notice, an alternative notice of appearance of another lawyer, and there is a substitute counsel that can file a notice of appearance. So counsel has a duty to ensure that there is an alternative counsel, and of course timing is important. So for example, in a case, in a recent case, a firm refused to represent a party, and the party then said that there was a material that they would suffer material adverse effect if the country's interest in the long-running arbitration. And so what are the duties then of counsel? There are several courts. So for example, a court in the BVI refused to grant in March 2022 an offshore law firm permission to withdraw from its representation of a Russian bank because, and I quote, the BVI said even pariahs have rights, and so you have to do it. And another more recent case also involving Russia here, decided by the PCA on an issue, a decision of 27 May 2022, the appointing authority dismissed a challenge in a dispute because the appointing authority in there said we have to balance the right of representation and the competing rights on one side of the right to choose counsel, but on the other side of an efficient process. So how do you do it? So what is the timing? What are the counsel responsibilities? Of course, there are counsel responsibility, and how do you ensure that your client continues to have representation? Would the answer be different, maybe depending on the extent of which what are the reasons why counsel is seeking to seize representation? So does it depend on what the state is accused of violating? Whether are fundamental principles of international law, or does it depend on what the underlying legal framework is, and is it why and why not should we try and take into consideration those issues?
Thank you very much, Chiara. I think those are all very interesting questions. The cases that you brought up are very interesting because, as far as I'm aware, they all involved representation before a national court system, either the U.S. or BVI, and there's another one in the Netherlands. And in those cases, any litigant, most of the time, needs a lawyer who's well-versed in the national, very technical procedural issues of how to represent a party before a court of that state. I think we should consider whether the considerations are different for cases in front of an international tribunal. Many of you in this room might know firsthand that in order to be that governments, their in-house lawyer teams tend to be very well trained in public international law, and it's an interesting role in that the government lawyer is both the client for the state, but also is a lawyer and can technically represent that state before an international tribunal. So I don't think necessarily the prejudice is, and this is, again, same disclaimer as the others, it's my personal view, I don't think the prejudice is the same for international firms withdrawing from representing before an international tribunal where the state has very well-trained and well-versed internal representation versus withdrawing from representing in the Netherlands or in the U.S. There is the one example you brought up of the PCA. I can just say that there it might have been exceptional because that case has been going on for 7.5 years already. So the in the balancing, the weighing between letting a party have the lawyer of its own choice, reputable counsel, versus efficiency, the efficiency was already pretty out of balance there. So if that had happened at the very beginning of the proceedings, it would have been a very interesting question.
And to add to that last point, non-appearance was also a feature there. So we don't have the published decision, so one can't say how much that was a factor or not, but at least according to the summary report we do have, it wasn't mentioned specifically as a factor, but possibly it was. Certainly, the idea of an entity, an individual, a company, a state even, being unable to retain counsel is as old as time in national legal systems. Think of, obviously in criminal law, one can think of, I'm sure from one's own knowledge of one's own legal system, examples of this. That being said, national codes of conduct for counsel regulate the matter differently. Some provide for specific grounds for withdrawal from representation. For example, if one is instructed to make an argument that one does not believe can be sustained in fact or law, that would be grounds for withdrawal. As was mentioned, there might be conditions attached to that in terms of securing alternative counsel. That varies, of course, across national legal systems. Others don't regulate the question at all. And it's sort of assumed to be left to the individual conscience and circumstances of counsel, and that client will be able to retain someone from somewhere. The late Sir Ian Brownlee, in the public international law world, was well known. He built a career on representing states that were not popular with his state of nationality, the United Kingdom. The late Judge Crawford, when he wrote an obituary for Sir Ian Brownlee, he related an incident in a particular case when Sir Ian had made his argument against the UK. He sat down and Sir Ian quipped, well, there goes the knighthood. But he was awarded one for services to international law, nonetheless. So what's different about this phenomenon that we've seen is not that it's new, the problem is new, it's how people are handling it, which is different. This boycott, which is not organized in any way because there's no centralized authority, is different.
Not technically a boycott in any conventional meaning of the word. I did want to mention, with respect to the standards that we have, the international standards, the Hague Principles on ethical standards for counsel appearing before international courts and tribunals, provides with respect to withdrawal, two sentences. Counsel may withdraw from a case where good cause for withdrawal exists, including a failure by the client to pay fees in a timely manner. Counsel exercising such right of withdrawal shall provide the client with reasonable notice. So put the fees matter aside. Good cause for withdrawal, that's it. That's all that is provided. Interestingly, the International Commercial Court's Code of Professional Conduct states that counsel may withdraw from an agreement, a representation agreement, if the client insists on pursuing an objective that counsel considers repugnant. Right? So that's, to some extent, subjective. Counsel considers repugnant. And clearly there are economic considerations for the law firms that have made the decision not to continue with the representation, but even in the international criminal context, there is this subjective element with respect to the character of the conduct.
Grant, may I ask, is that the client insists on pursuing an objective in the case where the representation is happening that's counsel considers repugnant? Because here, in theory, it's all, the representation predated the conduct, counsel did the conduct unrelated to the pending case. Does that affect anything?
I don't know. Any further thoughts on this one before we move to the next?
Just to say, the level of generality itself tells you a lot.
Yes, right. All right, so let's go to the next one. And again, Chiara.
Oh, thank you very much. So here the question is a little different. The question is, are there ethical issues to consider if counsel also acts in other roles in international dispute resolution? And this is the so-called double hatting, where we talk about a counsel that also practices as in two different roles, as an international arbitrator, for example, or as an expert or a mediator. And here the questions are, can they do it in terms of when it is simultaneous, or does it occur in the past? So allege improper relationship possibly with a person, or also possibly with an issue, as a counsel or advocate one side of an issue. Now, what we talk normally about dual hats and having two hats, there's no definition as such. And so even the views on how to regulate it and whether to regulate it is a matter of debate. And there's interesting questions there. Does a double hatting create situations where an adjudicator lacks a sufficient independence and impartiality because they may consciously or unconsciously decide in a way to favor their interest or the interest of their client? And does it affect the system of international justice, so to speak, in general? We create an appearance of impropriety, especially on issues relating to investment dispute settlement, investor-state dispute settlement mechanism, which is the subject also of profound reform in Ancestral Working Group 3. Or separately, is the ability to have two hats, to accept arbitration, is it necessary? Does it inform a counsel more? It gives practical experience. Does it matter in terms of including, allowing a diverse panel of arbitrators? Is it a necessary transition to switch from counsel to arbitrators more practically and economically? So how does that also impact disclosure and confidentiality? I think it's quite interesting because, and if you want to go to the next slide, it seems to be there is a disjuncture between what the concern that we find in the reform process and what arbitral tribunals have said, the relevant jurisprudence. So there have been several cases that exist that have been resolved by arbitral tribunals, both in terms of a party raising the issue of an arbitrator simultaneously also having another role involving the same party, or the arbitrator simultaneously having a different role involving a non-party to the dispute, or an arbitrator having in the past have the same role. And here, the arbitral tribunals have been quite conservative and have very seldomly decided to find that double hatting was questionable. So the arbitral tribunal have said that arbitrators should not simultaneously represent an investor in another case, proceedings against the same respondent, where sit as a respondent, arbitrator and counsel against the respondent, or no simultaneously advising a number of respondents, public entities in an unrelated matters. But there has been a little less constraining in terms of work, of counsel work not involving the same parties, and have said, for example, that because the communities are so related, there are communities between arbitrators and counsel, overlap is not by itself sufficient ground for disqualification, and something more must be shown. So, or in other cases, there's a choice that arbitrators, the arbitral tribunal have requested the challenge arbitrator to do, either choose between work as an arbitrator or counsel. In terms of previous work, very often the arbitral tribunal looking at challenges have rejected the challenge and have said that there's no prohibition of double hatting as such, but actually there must show some more specific facts that demonstrate the inability of an arbitrator to distance themselves from the work of counsel. Interesting also to show that some data talk about dual hats and how often arbitrators and counsel wear these two hats. So sometimes we also say the three hats, because maybe the hat of the expert also. And data shows that this is quite prevalent. So in a publication by Lanford, Ban and Lee, for example, in 2017, said in looking at more than 1,000 cases, had found that about 47%, at least one arbitrator engages in double hatting. So how do we regulate this issue? Do we need to regulate it? And there are different solutions. More recently, a number of multilateral and bilateral treaties have decided to completely forbid these dual hats. And so one has to choose one hat, either counsel or arbitrator. This happened, for example, for the CPTPP, the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, CETA, several investment treaties by the European Union, so the European Union Vietnam, but also is also contained in the model BIT from the Netherlands, the Slovak Republic, South Africa, and Morocco, giving a complete prohibition. And the similar prohibition also exists in institutional rules. So, for example, for the Court of Arbitration for Sport, there's since 2009, but also at the International Court of Justice, at the International Criminal Court, and some others, there's a prohibition that judges engage in any other kind of occupation, and presumably also that of counsel. So in international courts, we have that prohibition. And the Code of Conduct, Article 4, the Code of Conduct that it's now in its draft format, which is it's in process as part of the reform process of UNCITRAL done together between ICSID and UNCITRAL, provides specifically a limit on multiple roles. And here in the specific draft that is now being discussed, the draft says that unless the parties agree otherwise, an arbitrator shall not act concurrently or within 3 years from the conclusion of an investment proceeding, as a legal representative or an expert witness in another proceeding involving the same measures, the same or related parties, the same provisions of the same treaties, or possibly substantially a similar issue. And here the questions, and then I love to hear what the other members of the panel also say. There's several issues here, and this is still very much the draft of the Code of Conduct, because there are several issues that still have to be resolved. One is what does it mean to wear multiple roles? How do we define it? Is it only counsel arbitrators, or is it counsel, arbitrators, expert, mediator, and possible other roles? Is it just simultaneously, or does it also require a certain amount of time to be passed? And also, what kind of cases? It's only similar cases arising from the same treaty, arising from the same issue, or possibly on the same area of practice in public international law or investment arbitration. So many interesting questions that arise from this idea of prohibiting or regulating the wearing of dual hats.
Any comments here from colleagues?
Don't get me started on Article 4. This is, so without doubt, this is the most contentious of the draft provisions of the draft Code of Conduct for arbitrators. We, at the last meeting, did not achieve an outcome on draft Article 4 as yet. It's ongoing. It has been discussed before at length, and it tends to provoke very strong emotions, let's say, or views. What I would say, as the problem, at least ethically speaking, the problem on the arbitrator's side, allegedly, is that an arbitrator might use his position as an arbitrator to influence the writing of an award, such as to support his work as counsel in a similar case. And as Chiara pointed out, therein lies the problem. I think it's safe to say that, for those familiar with the draft Code of Conduct, this is Article 4.1a and 4.1b. Insofar as a party is concerned, same party or same proceeding, there is not so much contention on those. It's really more on the third provision there, 4.1c, with respect to a similar treaty provision is what we're looking at, and it might be broader than that. And then 4.2 is definitely contentious insofar as issue conflicts are concerned. But really, that's on the arbitrator side, that's the problem. Will an arbitrator do that? On the counsel side of the equation, will that same individual who's wearing those multiple hats use his position as counsel to make an argument for you, the client, in a proceeding in such a way as to support something he's trying to achieve as an arbitrator in a separate proceeding? That might be a proceeding that concerns you, the client. You might be involved in that as well. It might not. It might have nothing to do with you. So it is definitely one of the salient issues that prompted the entire Code of Conduct project. I think that's safe to say. And we have yet to achieve an outcome on it. I'm hopeful that we shall do so. But I think it's also largely an investor-state issue, this, largely because of the way the mechanics work on that. As Chiara mentioned, the International Court of Justice adopted a resolution a few years ago prohibiting external work. There was an emerging problem on that, which is now dealt with satisfactorily. So one doesn't want to exaggerate the importance of the problem outside of investor-state dispute settlement.
Thank you very much. I think that's a very good articulation of what the issues are, what the problems are, and also, as Chiara said, even going beyond whether someone will use their role as an arbitrator to create favorable case law to use as counsel. There's the alleged problem of just being more sympathetic with one side of an issue if you're currently, if you're currently advocating it. On the other hand, I think the questions on the screen are worth considering. Grant can correct me, but I mean, I think it's very hard to just starting out in the field make a full-time living just as an arbitrator. And if people are forced to choose one or another, people of my generation, frankly, the choice will have to be to be counsel. And then so that perpetuates the problem of what I've heard described as pale, male, and stale arbitrators most of the time. But I mean, Grant has had a distinguished career for so many years as counsel, which before he pivoted to an arbitrator. I think that's kind of the way how it goes for most people. So I think these questions about affecting the supply of experienced arbitrators and the availability of diverse arbitrators as well are worth considering. And if I've mischaracterized your career, Grant, please correct me.
I'm not going to touch the male pale stale business. I will say my impression is the trend is to prohibit double hatting. That seems to be as there is a trend towards more transparency in these cases, there is a trend in making this distinction. In investor state cases, now a more junior person can train to be an arbitrator in commercial cases, which gives one a lot of experience in organizing these matters that then can be used eventually in working in investor state cases and other cases where there is this, where there may be, depending on how this comes out, dual hatting prohibition. It is a concern though, where you particularly as counsel, where you see your adversary is sitting as an arbitrator in other matters and has the ability to influence the course of the law. Now it's, of course, these decisions are not strictly speaking precedential, as we have in our common law national systems, but they're very influential, and it is a concern. Yes, please.
Thank you. Just very briefly, I wonder, because both Armen and Alex mentioned this idea of having different areas of practice, and you said that this is most of a concern in investment arbitration, and you said it's difficult to separate. I wonder if it is possible just to say, okay, no, as some practitioners have said, okay, so I will do counsel for public international law, but then I will do only arbitrator for investment arbitration cases. Is it possible, and is it the right way to do it, or the cases are so intrinsically, or the community is so intrinsically, common that it's impossible to separate them?
One thing that distinguishes investor state cases from other, I think other public international law cases is that these treaties are fairly similar. I mean, there are, say, 3,000 bilateral investment treaties, but they're all more or less the same in their prohibitions. They all have expropriation provisions, fair and equitable treatment, and the cases all turn on the same 3 or 4 provisions. That is not the case in many of the other things that we do, which makes this particularly challenging to deal with in investor state cases. Let's move on, unless you have something else you wanted to.
If I may, completely agree with Alex. The dynamic on that also, when you get into it and the arguments people make, gets interesting because the experience bias in terms of appointments. So arbitrators being so concentrated as a pool. So that's within the hands of appointing parties, theoretically. But then one is thinking about whose advice they are taking. Well, it's largely counsel. So counsel as market controllers, potentially, and how that affects the dynamic between counsel and arbitrators. You need to get your magic 5 as an arbitrator as your first appointments to really get established. And then, as you point out, Alex, is that risk-reward factor of making the full transition versus not. And then remuneration is another factor. Remuneration rates for counsel and arbitrator are not aligned. And as counsel, theoretically, you can earn more, depending on how senior you are. So how much of an incentive that is.
So our next topic will be led off by Alex. You have a full and fair opportunity to.
Sure. So, the question is, may counsel represent a client against a state for whom or with whom the counsel formerly worked? Next slide, please. So here's the situation. A lawyer in government service works on an arbitration or on a potential arbitration. At some point, the lawyer leaves the government and joins a private law firm. And then the private party adverse to the government in the arbitration wants to hire the lawyer and to represent the private party in the second arbitration or in the same arbitration or in the related arbitration against the government. Can the lawyer accept the representation? Can the law firm accept it if it agrees to screen the lawyer? Who decides these questions? How are the questions decided? So There are 3 publicly available decisions ruling on challenges to the lawyers in these circumstances. In one of them, I should say, the facts were a bit different because the person worked for a third-party litigation funder, which was advising the private party to bring the claim against the state, and then moved to the government. And then it was the private party that tried to disqualify the lawyer. So in each of the cases, as a threshold matter, the tribunals found that they were empowered to decide the challenge. They didn't have to refer it to a court or a bar. And this goes a lot to what we were discussing earlier about what is the role of the home jurisdiction standards and the international tribunals. The tribunals found that it was not their job, nor did they have the authority to police possible violations by the lawyer of the lawyer's own national law or ethics rules. That was a question for the courts and the bars. Rather, the tribunal's job was limited to the international proceedings in front of them. And specifically, the tribunals had to balance 2 competing rights. On the one hand, a party's right to be represented by the lawyer of its choice, which we mentioned before in the context of the boycotts. Second, it's the adverse party's rights, or both parties' rights, to a fair process. And fair process includes protecting a party's confidential informations and strategy discussions, and it involves equal treatment of the parties. And also on this note, as another justification to not have this decided by national law, the tribunals said that either the case was before ICSID, where it is self-contained by design, it's all international, or if it was a case under another institutional rules like UNCITRAL, they found that the party's choice of the UNCITRAL rules displaced any national rules other than the mandatory law. So if we can then move on. The tribunals applied the Hague Principles. 2 relevant ones are Hague Principle 2.4, which says, counsel shall respect the confidential character of any information imparted to him or her in confidence in the proceeding. Now, any information seems pretty broad. What if it's facts that both parties know, or if it's publicly available information? And a Hague Principle 4.2, which says, counsel may not represent a new client in proceedings where a former client is party to the same or closely related proceedings, and there exists a material risk of breach of confidentiality. So all 3 tribunals distilled these provisions into the following test that's on the screen: whether there is a real risk that the lawyer could have received confidential information while representing the government in the first case, which may be of significance in the subsequent proceedings, and which may accordingly prejudice the government's right to a fair hearing. They said that clear evidence is required of this risk. And on this point, it's not a question of appearances. It's not enough to show that there is an appearance of conflict of interest. And they can't presume that there is a risk. So this is different from the standard when it's appointing arbitrators. When it's appointing arbitrators, if there is an appearance of impropriety, that's enough to disqualify. What justifies this distinction? I would say that it's because a party's right to their lawyer of their choice is a lot more personal to that party than the right to appoint a certain arbitrator. In theory, after you appoint the arbitrator, not in theory, there is no more interaction with that arbitrator. So the issue here is not the loss of the lawyer's opportunity to work on the case, it's of the party's personal right to have its own lawyer. So that could justify the requirement of clear evidence. And the state obviously can't be required to divulge the confidential information itself that might have gone to the lawyer, but it is expected to provide evidence of specific opportunities where the lawyer could have received confidential information. For example, what type of meetings the lawyer participated in, and the types of information generally that was discussed at those meetings, whether they were strategic and sensitive. And it's fact intensive. It often turns on how much involvement the lawyer had while in government, the extent of the involvement. And in 2 cases, the challenge was rejected, and in 1, it was accepted. So that's the issue. And if we can turn to the next slide, there are a few questions that arise out of this. Can the governments lawfully restrict the activities of lawyers who leave government service? Should they? Will this make governmental service less attractive? And how to address the risk that even if a lawyer does not recall working on a case, the lawyer's latent memories might be triggered as the case continues. So I'd love to hear my colleagues' opinions on these.
Yes, so investor-state dispute settlement is where the interesting stuff is happening at the moment in this field. So it's, again, why I'm going to refer to it. There's an interesting problem with which we're grappling in Working Group 3 on the relationship between the duty to disclose under Draft Article 10 and the potential for an automatic exclusion of appointment under Draft Article 4. So it's technical. I won't get into it in detail, but it does provide a parallel to this problem insofar as counsel are concerned. Now, we know, as the chairman mentioned, by my count, we've had 6 decisions in ISDS ruling on applications to disqualify in terms of counsel. So unlike maybe 5 years ago, we know that the power exists to do so. In interstate arbitration and adjudication, no, this has not come up. Arguably, there were cases where it ought to have come up, but there's a deep reluctance, I think, still to engage with this. And so even in the ISDS world, tribunals that have engaged with this have tended sparingly to refer to the guidelines that do exist for counsel. It's a matter of speculation as to why. My guess would be that they are trying to keep things narrow, just decide the issue that's before them, and not encourage more applications to disqualify. And this is the well-known problem with challenges. So we're thinking in terms of arbitrators. So with the code of conduct, we're again grappling with how whatever we come up with in the draft code sit within the challenges procedures and the challenges tests, which is again technical and complex. So it has come up, but the reality is that most of these applications fail with respect to applications to disqualify. Could governments lawfully restrict activities of lawyers? Short answer, yes, contractually, theoretically. So a sunset clause or whatever. So you're going away and for 3 years you cannot work for anyone else as counsel. Would that deter government lawyers from joining? Absolutely, it would be my instinctive reaction. But it all depends. Maybe not so much as might be assumed. In terms of the substantive issues that have come up with these applications, tribunals just haven't been convinced that counsel would have been privy as government lawyer to such information as wouldn't have come up anyway in the course of the arbitration.
Yeah, just very briefly. I hear that there's some guidance that maybe can come also from the domestic rules where we have a very generally a buffer, as you said, right? So a time in which that has to pass before a counsel could take maybe other cases. And I think here, not specifically, not completely on point, but I think in parallel we have the practice direction of the ICJ in terms of counsel and ad hoc judges requiring, is it 2 or 3 years, and a similar provision in the Code of Conduct for arbitrators and counsel. So here maybe it's the time that need to pass that might be of guidance and importance.
And the issue is working against the state. It's not working as a lawyer. It's working adverse to your former employer, the state. Reading these cases, these half dozen or so cases, I think there's a concern, particularly with respect to smaller states, that there's a limited pool of knowledgeable lawyers, and to have a flat prohibition without a very high standard that there is a risk, that there was some specific information relevant to the case that was available to the lawyer, I think tribunals are very reluctant to interfere with the client's choice of counsel. But I think the fact there's such a small pool in some states of knowledgeable people is a factor here. We have one more, if you'll bear with us a bit, we have one more problem, which we'll try to get through expeditiously, and this is for Armand to start with.
Is there a duty to avoid falsehoods when representing a state? Define falsehood. Next slide, please. So a few citations from the exhortatory guidelines to which we've referred. As you can see, they are not detailed. False or misleading is not defined, for example, in Hague Principle 6.1. And therein lies the problem. Knowingly false, in IBA Guideline 9, define knowingly. Even the commentary, I think, doesn't quite deal with it. Next slide, please. So, 4 scenarios, all of which have come up. Government lawyers may be asked to submit questionable evidence or advance misrepresentative or misleading arguments, quote, for the good of the nation, end quote. So here, probably the salient example is the Corfu Channel case, the Admiralty XEU orders that were not provided to counsel for the United Kingdom internally. So they had made the argument in writing and then obtained internally documents which showed that argument to be false, and were confronted with the quandary, what do I do now? Sahat Shawcross wrote rather acerbic letter internally saying, I have only one way to justify what I'm about to do, which is to continue to make the argument. My country, right or wrong. Mm-hmm. And it worked. The court on that particular issue, it didn't have the documentary evidence, so the argument succeeded, in fact, on innocent passage. Failure to provide an international court or tribunal with evidence underpinning a claim or argument. Well, there's a variation of that in Corfu Channel, but also examples of requests for production of documents, what I was referring to earlier by the procedural rules and the powers of the respective court or tribunal, requests to produce documents, refusals to those requests. What does the court do? And we've looked at this problem in the ILA committee I mentioned. Well, adverse inferences are there potentially, but there's a reluctance to use it. Representing a claim or argument that counsel actually know to be false based on evidence not provided to the court or tribunal. Again, this has come up. Iran-US Claims Tribunal, ICJ, interstate arbitration. So Qatar, Bahrain, the forged documents problem there. Witness proofing and the absence of a perjury mechanism for witnesses, expert or lay witnesses, or rules on accepted witness interrogation techniques. The example that's come up at the ICJ, for example, or the International Tribunal for the Law of the Sea, counsel is testifying. I have personally visited that site of that, whatever it is, proposed works, and I know it to be whatever. Well, you're not a witness. You're not being cross-examined, and so on. So this has been controversial. There's no perjury mechanism for witnesses, and there have been examples of where quite arguably witnesses have lied. The rules on accepted witness interrogation techniques do exist, but they're rather rudimentary, and they've sort of evolved by custom and practice rather than by any sort of conscious designing of what is permitted or not permitted for counsel to do in the courtroom. And again, where national traditions vary considerably, and ethical rules on what is allowed or not, because their own procedures vary.
I think we have one more slide with some questions here.
So the questions, is there sufficient incentive to avoid falsehoods? Some examples given there of incentives. And is the duty of loyalty to a client subject to a duty to the International Court or Tribunal to contribute to the fair administration of justice and the promotion of the rule of law? That is the magical question. And when one looks at the guidelines that are being developed, one might argue that they do not really answer it.
Yeah. You know, the lawyer's reputation is very significant. One of the reasons that states do hire outside counsel, of course, is because they, of the skill and experience, but also the reputation of the lawyers. And it matters to a tribunal if the lawyer is able to represent that that something is, they didn't have knowledge of misconduct, and work on the remedy as opposed to the substance of it. I mean, it's very unusual for a lawyer of high reputation to suborn a falsehood in a room like this, in a high-profile international arbitration, in my experience. So that whatever the standards develop, there will always be the people in the room and their own personal reputations. You know, with respect to my country, right or wrong, some of you may know of the Carl Schurz Park, which is about 40 blocks north of here, where the Gracie Mansion, the home of the New York mayor, is. He wrote in 1871, "My country, right or wrong, if right, to be kept right, and if wrong, to be set right." So this maybe goes to the idea of one's reputation and one's obligation to maintain it. Anybody have any further comments on this point?
Just very briefly, if I may, just maybe to finish on a maybe positive note, just to, I think not to, just to remember the duty that we say here, the duty to the international courts and tribunals, because I think it's important for Council to remember that too. And in Article 6.1 of the Hague Principle that was cited before, there's also an obligation of Council to present evidence in a fair and reasonable manner. And I think it's important to remember that when we think about representation, that you have a duty both to the state and the client and to the international justice system in general. Yeah.
We do have a few minutes. We're happy to take questions from the floor, if there are any questions or comments. Okay, very quiet group for lawyers. Yeah, okay, well, thank you very much then for your attention and time, and it's been a great privilege to present before you. Thank you all.